Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is on social media stemming from our Curious Lawyer series, and is a look at the laws that regulate us, our speech, and liability for companies that are in the social media space. We ask, is Twitter and Instagram liable for copyright and defamation ever, or are they so deeply immunized that they are essentially off limits? But first, and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs, and, of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, I can neither confirm nor deny. You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that, in fact, has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education that is often technical, difficult, or stressful. So sit back and grab a cocktail, if you are so inclined, and let's get going in our fascinating, crazy, and at times shocking ethics exploration of our judges. So let's get going. The scope of the issues that we're going to talk about today. You see here on the first slide, we are looking at online companies and online businesses that at the end of the day traffic in or deal in information about other people or businesses of some kind. Big picture of what we're going to do is look at the online social media companies and their liability, if any, for online copyright infringement and defamation occurring on their platforms, given the information and content being published. This information can be third-party informational commentary or others' actual content. What do we mean by that? Let's unpackage it a little bit. It could be me getting on a chat forum and saying something nasty about you, and you getting on the platform and saying something nasty back about me. And that platform that we get on, that act of logging in and sending a message over, for example, Facebook's Messenger board or some other website, that company now is in essence trafficking in or possessing this content that you and I, as we're engaged in this sort of defamatory war of words over the internet that you and I are sending back and forth, that company is possessing the content and it's retransmitting it. That is, it's broadcasting it. Then it's publishing it. Then it's showing it to the world via the service that it provides. And that, of course, triggers lots of questions about state to law for republication liability or copyright law, for example, which we'll also talk about today. The other example is simply email. Take Google. They have servers that they use. They provide, email to you and to me, and I may email you a copy of the new Star Wars movie, and it goes over Google servers to you, and you watch it. Now, I've engaged in an infringement by doing that, but Google has now reproduced that work in order to transmit it to you. So the ACT of having a business that even provides email or YouTube, as we'll talk about, where videos can be posted, can trip traditional copyright lines. The internet, in other words, has become such a massive and ubiquitous and important aspect to our lives because it is the central way that we as a people now are gathering information, interacting, and engaging with content and data. The internet and the platforms we use on the internet have become the central place people go, and this also requires a massive amount of regulation or limits in terms of how far the regulation will go. And this is a central thesis of what we are exploring today. What we're talking about when we talk about all these different companies, Yelp, Yahoo, Craigslist, broadly defined, we're referring to them in this presentation, is online service providers that I will refer to as OSPs. They are businesses that provide a service online that is on the internet to facilitate the public consuming information over the internet. Now, this is a different type of business to historical businesses, of course, that were the mechanisms by which content was delivered historically. What the internet has enabled, of course, is companies to be built around letting you and I communicate. Whether it's by emailing each other or uploading YouTube videos to YouTube, businesses, though, have been built to host and be the backbone to all of these activities. This is what we're referring to when we talk about online service providers in this presentation. And they've been given broad immunities based upon congressional actions that were taken in the early internet years. And so what we're going to look at and start with is liability for informational postings, and this really gets to tort and other sort of state negligence or state tort law liability for defamation or other behaviors. The other aspect is liability in the remedial scheme that exists for copyright infringement over the internet. So we will explore social media and online liability regimes of state tort and federal copyright as they intersect with us and social media. And along the way, we will also look at the social media platforms' terms and conditions, the contract you enter with them. And we will see just how broad a license you as a user give them in terms of copyright interests in your uploads, as well as grants of right to use your right of publicity. It's seriously broad, and you may be shocked to realize just what you give up by using the free service. On our next slide, as you see here, the history that ultimately led to this federal immunity that we'll talk about really starts with state common law and application of common law principles to online behavior. This is in the era before Congress even waded in, and so one of the earliest cases is in 1995. And this is before Congress even regulated the area, and it's called Stratton-Oakmont versus Prodigy case. You who are a bit older like me remember Prodigy. It was one of the early internet companies that gave internet access and bulletin boards. Well, what happened in this case is someone went up onto a Prodigy bulletin board and made a whole bunch of defamatory comments about the plaintiff, and plaintiff did not like it, so they sued. And they sued Prodigy, saying you're liable in tort for republishing liability from the anonymous uploader. They posted it, it's true, but you then republished it on your bulletin board. You exercise control over what gets published or not published. So you are simply liable under traditional state republication principles. The theory here was the same way that if I sent a letter to the New York Times saying I think so-and-so is a blankety blank, and I defame them, and the New York Times published that letter, the New York Times would have republication liability under common law principles. So what happened in New York is that Prodigy Services was held to that strict liability standard that's normally applied to original publishers, and it was found liable because it had involved in activity such as actively screening and editing messages that were posted on the bulletin boards. It was doing this because it was looking for particularly nasty content, porn, whatever, that type of stuff, and like the New York Times would be liable for publishing a defamatory rant by me about you. So is Prodigy under this ruling. That was the spark in the early internet years that prompted radical congressional action fast to reverse course. The theory was that because that type of reasoning had the massive capacity to really chill the development of the internet and hinder the development of this massive new technology that was opening up new means of communication and sharing of information. So that early internet company prodigy that has died now, well, it was the cause of the modern internet world and social media world we now inhabit. Not only did it die for whatever reason in the marketplace, but the ruling it engendered died too by the massive federal preemptive hammer. This brings us to Section 230. And so Congress enacted Section 230 of the Communications Decency Act in 1996. We see it here on this slide, and it is codified at 47 U.S.C. 23C, and this is the money language we have quoted for you. This is the core of what is central to online internet immunities today. Quote, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. End quote. If you read it twice, if you have to, you see it is very, very broad in terms of absolute immunity. And further provisions provide that it ends up preempting any and all state claims based thereon. Here's the definition of what an interactive computer service is. And that's the same basic definition we're using for online service providers, as we talk about this in the copyright realm, which we will address soon. But basically, quote, interactive computer services, end quote, refers to information services systems or access software providers that provide or enable computer access by many users to a computer server, including a service or system that provides access to the internet and such systems operated or services offered by libraries or educational institutions. It's very, very broad, and so what it means is it's Verizon or Cox Internet, it's Yahoo, it's Google giving search, giving email, kind of the backbone access provisions. And then in the more modern sort of Internet 2.0 world, Facebook, Instagram, Snapchat, those types of businesses that have gone a step further but are still built on facilitating communication between people over the internet. Let's go to the next slide, which brings us to the twin goals of Congress with the Section 230 immunity that Congress created in 1996. The first goal was that Congress wanted to encourage the unfettered and unregulated development of free speech online and to encourage e-commerce and its development online. In other words, the development of business and e-commerce type activities online that help everyone. The second goal, by enacting this immunity provision in the Communications Decency Act of 1996, was to, quote, encourage interactive computer services and users of such services to self-police the internet for obscenity and other offensive materials, end quote. These are two massive goals that frame the statute and its interpretation over the ensuing decades. This brings us now to one of the first major cases to come down after the law's enactment. And it's really one of the foundational cases in Section 230 law. After the enactment of the Section 230C immunity, this is the case of Zeron versus AOL. And so now we're bouncing from Prodigy, which precipitated the need to pass the Communications Decency Act provisions, to AOL, which was one of the first ones to be sued after they were enacted on a state tort liability theory. And this case involved an unhappy plaintiff, because this is what happened as you see in the facts. There was a false advertisement placed on an AOL bulletin board, and the false advertisement directed users to call up the plaintiff, and, this obviously resulted in the plaintiff receiving endless amounts of harassment and calls and whatnot at his phone number. Plaintiff was not happy, as you can imagine, being bombarded by harassing phone calls, and so the plaintiff sued AOL saying, this is your bulletin board. My personal phone number was published on it. And it's obviously harassing. And given the content and nature of it, you should have taken it down. You didn't. And that resulted in me suffering emotional distress and other state tort-based claims and damages. Plaintiff sued, and here is what the Fourth Circuit held. Congress recognizes the threat that tort-based lawsuits pose to freedom of speech in the new and burgeoning internet medium. But the imposition of tort liability on service providers for the communication of others represented for Congress simply another form of intrusive government regulation of speech. Thus, Congress made a policy choice not to deter harmful online speech through the separate route of imposing tort liability on companies that serve as intermediaries for other parties' potentially injurious messages. The case thus held immunity. And so one of the central lines that traverses that holding, as you can see, is that AOL is simply an intermediary. It's a facilitator of communication. It is not really engaged in curating the content and editorializing the content. In publishing the content, the same way the New York Times makes those conscious, volitional business decisions about what content it's going to publish, it's really an intermediary. That is, it's just a service provider providing a means of communication. Therefore, if I defame you, then you can sue me. You can do your discovery, and you can find out who I am, and you can go after me the same way you have always been able to go after me under state tort law. You just can't hold the internet company liable. This case is a seminal foundational case when it comes to online social media liability principles. Let's take a look now at some cases, and we're going to look at both sides of the immunity line. You can see in our chart here, we'll look at a few cases where immunity has been upheld and a few cases where immunity has been denied. And this will start filling out the constellation of case law and the puzzle, so to speak, to give you a sense of where these fault lines are. The first case in our column there is a case against MySpace, and this was a suit where a plaintiff sued MySpace, saying your policy, MySpace, of allowing minors to register and create accounts without making sure that they're adults and not taking proper steps to make sure that these are not minors, has allowed minors to create MySpace accounts. They lie about their age, and that ends up, exposing minors to communication and issues that could be dangerous or harmful to them, and you should have taken steps to make sure that minors don't sign up on your service. The plaintiff legal theory was that it's negligence and is damaging to do that. MySpace defended and said, we're simply providing a means of communication. It's not our problem. We are a service provider on the internet, and this is not something that can subject us to state tort liability for our policy decisions about how we run our service on the internet. The Fifth Circuit said, yes, we agree, and MySpace received immunity. Another example is one from the California Supreme Court in 2006, and there we have the defendant being an online discussion group blog type service that's built around women's health. Defendant was running this service and posted some third-party content, and that third-party content had been content that was allegedly attacking the plaintiffs. Here, the plaintiffs were doctors critical of alternative medicines, and those plaintiffs didn't like the fact that they were being criticized for being hostile to alternative medicine. So they sued the online discussion group, and the online discussion group said, no, you don't get to sue us for state defamation tort law because we're running an online informational blog. That is, people are communicating and they're saying things you don't like. Well, too bad it's not our responsibility. The court held immunity for them too. The final example brings us to Craigslist, and you all probably know Craigslist. It's sort of like eBay meets the classified pages of old newspapers where you can buy or sell anything. You can rent apartments and you can do all sorts of things. It's kind of a stripped down website that's very minimalistic, and it kind of looks like the classified pages almost. It also turns out that you can find adult services on there also, and a sheriff in Illinois was not thrilled by the fact that in his local town, Craigslist was facilitating these adult services and connections between adults for prostitution. The sheriff felt that Craigslist is creating this means for people to do it. And so it's creating a public nuisance because there's all this now prostitution going on in my jurisdiction. He didn't like it, so he sued Craigslist saying that you've created a public nuisance. Craigslist again got immunity from state tort law. The ruling was that you can't regulate how Craigslist provides its mechanism and services to facilitate those types of communications between people. And so the message to the sheriff was that if you want to go after people for engaging in prostitution, then go after them. But don't go after Craigslist. And so as you can see from these cases, at least the breadth of the immunity against a variety of different kinds of state tort law theories and a variety of different sort of factual situational settings for service providers is pretty significant and pretty broad. Now let's look at the other side of our chart. We're going to look at a few examples where there was no immunity given, and we're going to assess those fault lines to understand them. The first couple cases involve Yahoo. And I don't mean to pick on Yahoo here, but it just turns out there were a couple good cases where immunity was denied. They both involved Yahoo. The first one is a user of Yahoo's online dating service. He sued when he discovered that Yahoo had created false profiles and sent other users those now defunct profiles to entice them to resubscribe. This user didn't like the fact that a false profile of him was being used to try to get other people to join the dating service, and that Yahoo had actually taken those and disseminated them. So he sued Yahoo. Basically, Yahoo said, hey, look, we're just an online service provider. This is a sort of a dating platform. It's kind of like MySpace type situation. We have immunity. But the court there said, no, you don't get immunity. And the reason Yahoo didn't get immunity is that Yahoo had engaged in sort of its own business volitional decision to create content itself. Those fake profiles were created by Yahoo and then disseminated those to get people to sign up for Yahoo. That's an example of no longer being just sort of a passive neutral intermediary and being too actively involved in business decisions. And it was those Yahoo decisions that triggered state liability, as opposed to the communications that may have resulted that the person didn't like as a result of it. And so that was an example of where Yahoo, for its volitional activity, could face liability and wouldn't get immunity. Another example is the Barnes case we see in the chart here. In that case, there was a false profile of the plaintiff put up, and the plaintiff complained to Yahoo. Now, a Yahoo employee said, I promise you I will take that down, I'm sorry. But the post was not taken down and continued to injure the plaintiff. Now, this is a case where there was immunity for part of what happened and no immunity for part. Let me explain. When the plaintiff sued Yahoo, he said, you're negligent for even allowing the post in the first place. That defamatory false profile of me that someone else posted, and you're liable because you told me you would take it down, and you didn't. As to the first component, the court said, no, Yahoo does have immunity. That's just like our MySpace or Craigslist case. If Peter posts a false profile about Paul, then Paul needs to take it up with Peter and not Yahoo. But the court held when Yahoo's own employees said, don't worry, I promise you we will take it down, and the person did not then take it down, well, then there was continued injury. Plaintiff was able to pursue a state promise-based theory because of the promise made by the Yahoo employee. So again, you see the fault line here is being involved in actual activities, which causes the service provider to actually do something that gets the service provider involved in the content trafficking, and that can trigger liability. The final example is where Mindspring was hosting a website that infringed Gucci's trademarks. In other words, someone out there created a website and they're infringing Gucci's trademarks. Mindspring is simply hosting that infringing website on the Mindspring servers and platform. Now, it was told multiple times by plaintiff that this is infringing our intellectual property, and critical here federal intellectual property laws, but Mindspring didn't take down the site. So Mindspring was sued on a contributory trademark infringement theory. Mindspring said, hold on, we can't be liable under the federal IP laws for knowingly allowing this infringement to continue because we have immunity under Section 230. But, and this is an important limit, because the court noted that, no, the immunity grant in Section 230 relates to state tort law. Basically, what Congress made very clear in enacting Section 230 is that it doesn't expand or limit the scope of federal intellectual property laws, and those still stand. Thus, it can't override existing IP laws. And so this is why for your clients who may be intellectual property holders, it's easier to get recourse about content to be taken down off of the internet by anonymous folks over some web service online service providers when it involves federal IP violations. Yelp is just a fascinating case study in terms of Section 230. So this is the case of Yelp, the California Supreme Court, and some very angry lawyers. So here's the basic situation. Someone's angry because someone else posted a negative review on Yelp about you or your business, and it's not true. It's false. It's bogus, and they want to get it down, and what do you do to get it down? Well, this happened to a law firm, and this is why we get the most creative of all cases, is when lawyers get defamed, because now you see creative lawyering in action. What does the law firm do when it has a client who starts leaving what the law firm believes are defamatory posts about the law firm online? The law firm doesn't just sue the client for defamation. What it does is sue the client for defamation and seek an injunction to require Yelp to take the defamatory post down. So here's what happened. The underlying client's name was Bird & Bird hires this lawyer in a personal injury case. Bird becomes unhappy at some point and gets another lawyer and leaves a Yelp posting anonymously. But as the law firm claimed, this came from Bird. And here's the posting that angered the lawyer. Quote, steer clear of this law firm ! And research around to find a law firm with a proven track record of success, a good work ethic, competence, and long-term client satisfaction. There are many in the Bay Area. With some diligent, smart interviewing, you can find a competent attorney, but this won't be one of them. End quote. Now that is defamatory, if untrue. It's certainly not, puffery. That wouldn't be subject to state defamation law. And so the law firm filed a lawsuit saying that's defamation. There was a default judgment since the defendant didn't appear. And the court found it defamatory. And so as a matter of law, now that is defamatory. And this is where the creative lawyering came in. The law firm never sued Yelp. That is, because of Section 230, the law firm certainly knew that Yelp couldn't be subjected to a lawsuit. So what the law firm did was get their default judgment, and then in the judgment have an order issued that non-party Yelp must remove that defamatory post because it's now been adjudicated to be defamatory. Yelp gets the court judgment and injunction. Let's see how they reacted. Yelp's in-house lawyer apparently found that this was not amusing. Yelp said, no, you don't get to get a judgment against a defendant or against the named party by default, and then wrap us into the judgment without any notice whatsoever. And aside from due process problems that Yelp raised, this is barred by Section 230. The trial court denied it and said, nope, it's just an order to remove an adjudicated defamatory post online. The California Court of Appeals affirmed and said, yep, this is no big deal. Yelp goes to the California Supreme Court to seek its Section 230 immunity. What does the California Supreme Court do? It grants review. Let's now see what it holds. Well, in a nutshell, the California Supreme Court undid everything. Here's what it did. The Communications Decency Act immunity applied, and providers are immune from any quote claim arising out of content originating from a third party, regardless of the theory underlying the cause of action. End quote. So in other words, what the California Supreme Court said is kudos to you lawyers for your very creative tactics here. But you can't use those kinds of creative backdoor litigation strategies to get what Section 230 would never let you get in the beginning. In other words, if Yelp had been sued to seek injunctive relief to remove the post, Yelp would have received 230 immunity out of the gate and been dismissed from the suit. And so you can't do an end run around that by bringing them in on the back door in a judgment and an injunction. Quote, Yelp is inherently being treated as the publisher of the challenged reviews, and it is not engaged in conduct that would take it outside of Section 230's purview in connection with the removal order. End quote. And so the result here is that the judgment as to Yelp was vacated. This is a good example of the difficulty posed by online defamation that is endless across social media. You cannot simply sue the social media platforms to remove defamatory content in light of Section 230. There has been a little bit of congressional action back in 2018. Then, the scope of Section 230 immunity was actually amended and narrowed to mandate that platforms take affirmative steps if sex trafficking-related content is on their services. If they don't take affirmative sex steps to remove sex trafficking content, then they lose all immunity and they can be subjected to liability and even criminal liability. Now, that narrow amendment to Section 230 expressly didn't touch the rest of the broad immunity, so it's been taken back a bit, but expressly not taken back further. Many in Congress are in fact questioning the breadth of this immunity and what needs to be done. And here's a quote from at least Senator Dianne Feinstein when she was speaking to all the large social media companies' general counsels in 2018. She said, quote, "You've created these platforms and now they're being misused. And you have to be the ones to do something about it, or we will." End quote. In other words, all this stuff is going on over your services, you're making money, you're profiting from it, you're standing back, being neutral and not doing anything. But if you don't start doing something to deal with this, then we are going to. I think what she's referring to when she says we are going to is we are going to either affirmatively legislate burdens and duties on you, or we're going to start repealing the scope of 230 immunity and let state tort law now regulate you. Now, the Supreme Court at the same time has actually likened these social media services such as Facebook to traditional public squares subject to sort of First Amendment principles. And this is sort of a significant step that's raised a lot of really fascinating questions. And this comes from a case involving a 2008 North Carolina statute. I'll tell you a little bit about it. In 2008, North Carolina passes a statute making it a criminal offense for a registered sex offender to access social media sites that include children. The defendant in this case had registered as a sex offender when he pleaded guilty to a sex crime when he was 21 with a minor, and he then accessed a social media site. Then, he was charged with a violation of this law, and he challenged it under the First Amendment, saying, "You can't make a law that you know interferes with my free speech rights." Writing on behalf of the court, Justice Kennedy said the following, and it's very, very broad language, which could have a lot of import in terms of future cases dealing with the regulation or limits on social media platforms. Quote, "Social media allows users to gain access to information and communicate with one another about it on any subject that might come to mind. By prohibiting sex offenders from using those websites, North Carolina with one broad stroke bars access to what for many are the principal sources for knowing current events, checking ads for employment, speaking and listening in the modern public square." End quote. In other words, the internet and these social media platforms and websites, many of these OSPs, have become almost a modern public square, equivalent to the traditional public square, where people engage in communication and discourse. That being the case, then, it starts raising real First Amendment questions about the scope of the state's ability to regulate those sites under the First Amendment, but also those sites' obligations, and to traverse and deal with First Amendment law. So this is just sort of the beginning of a burgeoning new era in terms of potential regulation on the immunities of these sites. But before we move to the second area of immunity for social media sites, as it relates to copyright, let's take a quick look at the social media terms and conditions to understand just how much you give up when you use the sites. We will use Instagram as our template, and you may be surprised to learn some of these contractual terms that control your relationship and what they may do with your posts and uploads. Here are two provisions from Instagram that effectively are full licenses to your copyright interests in your photos, videos, or posts, as well as a grant of your personal right of publicity in your name and likeness to Instagram that it can use in its advertising. And it's given by you for free, simply for using the service. Here's the copyright one. Quote, "You hereby grant to us a non-exclusive, royalty-free, transferable, sub-licensable, worldwide license to host, use, distribute, modify, run, copy, publicly perform or display, translate, and create derivative works of your content, consistent with your privacy and application settings. This license will end when your content is deleted from our systems." End quote. So you upload a cool video you made. They can copy it, change it, and go monetize it. That's the copyright grant you make. Here is the personal right of publicity grant you make. Quote, "You give us permission to show your username, profile picture, and information about your actions, such as likes, or relationships, such as follows, next to or in connection with accounts, ads, offers, and other sponsored content that you follow or engage with that are displayed on Meta products, without any compensation to you. For example, we may show that you liked a sponsored post created by a brand that has paid us to display its ads on Instagram." End quote. So you now have allowed them to use your name or photo in their advertising efforts on Instagram. Be careful what you like or follow. Your name may be then associated with liking or supporting ads for the content you follow or like. Now you understand what the user gives to social media. So let's now look at how that copyright grant you made works and what copyright laws do to regulate how far social media and internet platform companies can go with their services and your content. First, state tort law immunities, and then we will look at federal copyright immunities. Let's get going. Social media, of course, includes not just written posts and content, but lots and lots of photos and videos too, and those often trigger copyright questions. Now we're going to talk about online liability and immunities for copyright infringement occurring over the internet over online service providers' platforms. Instagram and YouTube and TikTok, of course, being the principal and well-known business that have lots of video content uploaded on it by users for viewing and public broadcasting and review, and even downloading by other users. Now here Congress, just the same way Congress entered the internet fray in 1996 to regulate it with online immunity, Congress did the same thing with respect to copyright liability in 1998. And the principal statute that we're talking about is the Digital Millennium Copyright Act. It was passed in 1998 to address online infringement for online service providers to deal with the fact that they may be technically liable for copyright infringement for much activity occurring over their lines, and to immunize them in effect and give them a safe harbor from what would otherwise be tort liability for copyright. Now remember, copyright liability is a strict liability tort in essence, and so liability occurs whenever JoQ Public's acts of infringement may cross an OSP wire. Here's an example. When you reproduce another's work, such as when I find a photo on the internet, I download it to my computer. The act of downloading the photo to my computer, I've now infringed copyright. And when I upload that to YouTube and YouTube then reproduces it, stores it on their servers, publicly displays it, YouTube has technically infringed copyright. It's because copyright is a strict liability tort, and it's because it's so easy then for online service providers that are providing this kind of backbone technology that allows people to communicate to get caught up and embroiled in the strict liability tort of copyright that Congress came in to act and legislate. That is, Congress came to deal with this issue in order to, again, allow the development of the internet. And so the result of that was the 1998 Digital Millennium Copyright Act. Let's look at the purpose and intent now. These are quotes from the Senate and House reports in terms of the congressional intent, in terms of the issues being confronted, in terms of what Congress was hoping to do. The first one is from the Senate report. Here's what's written. Quote, "In the ordinary course of their operations, service providers must engage in all kinds of acts that expose them to potential copyright infringement, liability. Service providers must make electronic copies in order to host most worldwide websites." End quote. The next quote comes from the same Senate report. "Service providers and copyright owners must cooperate to detect and deal with copyright infringement." Now, there's limits to this, though. But those who repeatedly or flagrantly abuse their access to the internet through disrespect for the intellectual property of others. In other words, we're talking about repeat infringement. Flagrant infringers constantly taking advantage of others' works. Those should know that there is a realistic threat of losing that access. So what Congress was saying is, we want to make sure that neutral conduits don't face liability. But if they're just going to turn a blind eye, basically, and allow flagrant infringement to constantly occur over their service, then you're not going to get immunity. We see in the DMCA in Section 512C of Title 17 of the United States Code. This is the principal safe harbor as it's known, or in other words, immunity. In some sense, you could look at it in terms of online service provider protection. The general rule is that these online service providers are not liable for infringements of copyrights by reason of the storage at the direction of users. For example, users using their service, the platform is not liable for those infringements occurring even though material resides on their systems where three basic requirements are met. First RT, where the service provider has in fact adopted and reasonably implemented a policy that provides for the termination in proper circumstances of repeat infringers. In other words, if you're running YouTube or Instagram and you just know that Peter is every single day infringing George Lucas's copyright in Star Wars because he keeps uploading clips, and George Lucas keeps complaining about it and Peter keeps doing it, well, at some point you need to stop Peter from having access, otherwise you're going to have liability. The other aspect of the safe harbor is that the service provider must not receive a financial benefit directly attributable to the infringing activity where the online service provider has the right and ability to control the activities occurring. And the final requirement goes to sort of the level of knowledge of the online service provider. And that is the online service provider does not have actual knowledge that the material or an activity using the material on the system or network is infringing. This is an actual knowledge idea. But even if there's no actual knowledge, still, the service provider must not be aware of facts or circumstances from which it's obvious that infringing activity is going on. This is sometimes referred to as red flag knowledge. This is the idea that if you're given red flag knowledge about actual infringement, at that point you need to act expeditiously to remove content, and if you don't, then you can be subject to liability and you lose your immunity. So that was the balance that in the copyright realm Congress enacted in the late 1990s. At the same time, it was enacting Section 230 on the state tort side. The questions we now ask are as follows. What's the net result from the Digital Millennium Copyright Act for our online service providers building their businesses? What's the net result for copyright holders wanting to protect and monetize their content and not have it infringed? The net effect is as follows. If an online service provider has content published on its site that was genuinely user uploaded, then the online service provider has no copyright liability if it lacks actual or apparent knowledge, or if it has such knowledge, but it expeditiously removes it, and if it lacks a financial benefit, and has adopted a policy for terminating repeat infringers. That in essence puts a level of duty on the online service provider to engage with its content to some extent and its users, and make sure that it has a system in place to at least deal with receiving complaints from rights holders, addressing them, and terminating users in appropriate circumstances. So in other words, for copyright owners, if those factors are met and they want their copyrighted content removed, then they need to send a takedown notice to the social media site. And that's the balance that Congress struck. Rather than being able to just straight file a lawsuit, you need to reach out to the service provider, let them know about it, give them a chance to take it down. That's the balance that's been struck. Your remedy is to get it removed before you can seek money from the online service provider. And the social media site will not be liable if it addresses the takedown notice properly. Of course, if you want to seek money from the infringer who actually uploaded it, then you can always do that, and none of these laws touch those who may upload in the first instance. This only relates to regulating, of course, service providers who have the content sitting on their servers. Let's look at what the takedown process is. The takedown process requires that online service providers provide some easy way to find and easy to understand takedown process for rights holders. It can't be some overly cumbersome or complex and impenetrable system so that if I'm a rights holder, I can't even figure out how to find you and get in touch with you. In other words, you have to have some very clear links on your website that make it very easy to notify the online service provider at a very clear emailing address. And then it's a very simple format in terms of how the information can be given to get infringing content taken down. It's got to be in clear, plain English so that it tells how one can submit the complaint. You have to allow the means to submit a takedown notice that may have multiple URLs showing multiple locations of infringement. It's got to be accepted by email or even a web submission format from the rights holder, and generally upon receipt access to infringing material, really should be terminated within 1 to 2 days by the service provider to be safe. That's not set out in the code. That's just the rule of thumb that's developed through case law and litigation. But once you get notice of infringement, the social media site really does need to move pretty quickly. And so this does require that when they are running their businesses, they need to have sort of a takedown task force or employees just kind of dedicated to dealing with these takedown notices and getting to the bottom of them. Now, there's a counter designation process also. This means that upon a rights holder complaining about infringing content and the content then being disabled by the service provider, the original uploader has a chance to say, hey, I want to make a counter designation. They can say, hey, I disagree, I did not infringe. And that person can then explain it, and that response then can allow the service provider to re-provide access to the content. That then puts the burden back on the rights holder to say, no, I disagree with the counter designation, and I'm going to file a lawsuit because that person doesn't have rights or their claim defense is invalid as a matter of law. That then triggers the court process. So let's see some cases in the courts now. Let's now get to YouTube. The central question we're talking about as we look at YouTube, of course, is we have the monetization of other people's content. Who pays and who gets the money? This is what gets to the root of the battle between online service providers like YouTube and rights holders. You have rights holders who create the content and want to monetize it and make money. On the other hand, you have YouTube that doesn't create the content and has a bunch of people in the world, millions, hundreds of millions of people, uploading content. YouTube makes money from that content by ad revenue, just eyeballs. For example, if I upload Star Wars and 1 billion people watch it, YouTube would make a lot of ad revenue, and that ad revenue is going to YouTube. It's not going to George Lucas or Disney. That's the root social and economic, indeed practical legal issue that has now driven litigation. And so the YouTube case comes out of the Second Circuit, and it involved a whole group of plaintiffs, Viacom and the English Football Association, which is the English Premier League, that owns the copyrights to all the English Premier League soccer games. They sued YouTube, and they argued that what is going on here is that clips of our content are being placed on YouTube. They are encouraging it. They're infringing. You're not taking steps to remove them or to terminate repeat infringers, for example, and you're profiting off our content. But that's our content to profit off of. So the argument goes, YouTube is not allowed to run a business like this. You're not the type of business entitled to this safe harbor. The Second Circuit disagreed. The Second Circuit, in a very significant decision which has really set the national stage and national standard, confronted a few arguments. And so the first one was that Viacom and the plaintiffs had argued that YouTube lost its safe harbor protection because it had a general awareness of infringement and therefore had the obligation to take commercially reasonable steps to protect it. That argument was rejected. What the court said is the fact that YouTube may be generally aware that Joe Q Public is sending infringing content doesn't put the burden on YouTube to now run a police state, in effect, over YouTube and monitor every piece of content, and on a content-by-content upload basis to figure out if it's infringing or not. That's a massive rejection of Viacom's argument. It allows YouTube to stay above the fray and, in effect, have a general level of awareness that its service may be used for infringement, but maintain immunity. Second, Viacom argued that there was so much content that was infringing that YouTube knew about that YouTube was, in effect, willfully blind, and so really had apparent knowledge. But this too was rejected. It's sort of the same or a similar issue to the first one, and that is there was no affirmative duty to monitor content placed on YouTube. And that's a significant part of the holding. Finally, the court held that on the right and ability to control aspect of the immunity, it really requires item-specific knowledge. This is another significant component to this decision. Thus, this content-specific knowledge is what the courts are looking for as opposed to general awareness. But of course, from the rights holder's perspective, it's very hard for any service provider to have item-specific knowledge when they're getting 10 million uploads a day, for example. I mean, of course, they don't have item-level knowledge, but they may have massive general knowledge. However, the way the Second Circuit came down on that line was strongly in favor of the online service providers. Now, there was one small exception to this decision, of course, with almost all legal cases. Here, factually, is what happened. YouTube is getting all this content uploaded to it from the public. And YouTube sat down and it looked at some of the content and it plucked out certain pieces of the content and decided to syndicate that content out for a business. But as to that, the Second Circuit said, no, that's not the type of thing that gets immunity. That's potentially a volitional business decision, and you're now interacting with the content and you're picking pieces of content, you're choosing to syndicate them out and license them in effect. If you want to do that, then you take responsibility for it. You cannot accept user submissions and have immunity because those things are being seen. And also then treat that content as sort of cleansed in effect such that you can do whatever you want with it. Thus, on that small point, the case got sent back for the questions to adjudicate YouTube's liability on that sliver of content. Now let's look at the Ninth Circuit. This case is UMG versus Shelter Capital. It has adopted the same basic standard. Here we had a very, very similar case. We're dealing with a company called VO, which is a website service that allowed people to upload videos and share them with others. Users had to register to upload and publish their video content, and once users uploaded their content to the servers, then the defendant just had an automatic software process that simply took the uploaded video and converted them to a different format so it could be broadcast through the network. Thus, at that point then, it's published for anyone to go to view. At the same time, the defendant used an automated software, and did extract some user-embedded metadata that allowed searches to occur on the network. Now, what defendant also did, and YouTube has done this too and still does this, is employ advanced hash and other technology to block content flagged by rights holders. What that basically means is if George Lucas complains that Star Wars is Mindstar, Star Wars gets hashed in effect. And this is just a technology that takes snippets of Star Wars, puts it in a database. And if someone uploads another snippet of Star Wars, the database compares it and sees, nope, that's already been flagged as being infringing, and then it stops it from ever being re-uploaded. And that technology was relevant to their immunity under the Digital Millennium Copyright Act safe harbor. They're not liable for copyright infringement. And critically here, what the court said is that knowledge of infringing activity in general is not broad or general. It must be focused to a particular video is at issue, and that those are the page sites for you if you want to read in more detail. And at the same time, the service provider cannot bury its head in the sand to avoid knowledge. And that's an important point, and this is where the Ninth Circuit has perhaps not gone as far as the Second Circuit. What the Ninth Circuit has said is, look, while it's not enough to just say there's general knowledge, we do say there's this sort of an anti-ostrich admonition. That is, you can't willfully stick your head in the sand so that you can be blind to data that would let you know your site is being used for infringing purposes. And so ultimately, the facts must be those that make specific infringement of a given work obvious to any reasonable person. And that's the Ninth Circuit's rule. Let's look at some more case law. And here is social media site LiveJournal. This case is Mavericks versus LiveJournal from the Ninth Circuit. It's from 2017 and it's reported at 853 F3D 1020. It deals with celebrity photos and online liability, and disclaimer, I represented the plaintiff in that case on appeal. So here's what happened. The defendants had a website called Oh No They Didn't. It's sort of an online celebrity curated website, and it's a website that was devoted to celebrity culture. It was built around discussing and exploring celebrity culture and celebrities in America. And so the rules of the site asked for users to upload current celebrity content, whether it be written or photos, entire articles, etc., and those were then submitted to the defendant's website. The defendant had moderators who would preview the posts before they would be published to the world. And they reviewed them and approved them following those basic rules such as, is it timely? Is it current? Make sure it's not pornography. If it's political speech, it's not for us. The website moderators, who were unpaid volunteers it appeared, but they were website moderators, would make the decisions to allow or not allow the content to then be ultimately published. The defendant gets a summary judgment granted to it under the Digital Millennium Copyright Act by the trial court. It goes on appeal to the Ninth Circuit, and the Ninth Circuit reverses. What the Ninth Circuit holds is that whether the users uploaded the content or the moderators actually uploaded it, since they were screening and approving it for publication under the site rules, really made it a fact question as to who was even uploading. But if the moderators were making content-specific decisions to approve particular content to be placed on the sites, and there were fact questions about whether those moderators were agents of the site, then the safe harbor couldn't be granted as a matter of law. And the case really needed to be remanded for trial to address that threshold issue of whether those moderators were the ones actually uploading in distinction to the people in the public. Second, whether their acts bound the company. So the key difference to YouTube is that, and this is one way of thinking about it in terms of your practice for clients that may be running online service businesses, is as follows. YouTube really functioned as a very neutral sort of anything and everything site. I mean, other than screening for obscene, illegal pornography and child pornography and the like, which is illegal, it really isn't anything and everything. You can post a video of your cat, sitting on the table, and they accept it. They don't reject it. It's not a specifically curated website that only accepts certain content, which is then reviewed by a set of rules to make sure it's then published to capture the best. And so and this is sort of the point of the case really, is that the more a modern online service provider business that's being built around the Digital Millennium Copyright Act wants to control and curate and editorialize the content that's sitting on its servers to curate a niche site, the more it's going to run into trouble with copyright laws. In that case, the less likely it is going to be able to get immunity, and that is effectively the holding of this social media case. But, as our next slide will show where celebrity photo owners prevailed, the owners of pornography, it turns out, failed. This case, and again a disclaimer, I represented the plaintiff in this case also. This case is Ventura versus Motherless. It's reported in the Ninth Circuit from 2018 at 885 F3D 597. And like the case we just talked about, this case deals with online liability of an online service provider trafficking in user-uploaded content. And this time it's adult content. My client was an adult content company that made adult videos. And so here are the facts. The adult content is uploaded to the Motherless website by really many thousands of users that it has. Some users uploaded hundreds of thousands of videos, actually, it turned out. Many takedown notices had actually been issued to one particular user who had uploaded hundreds of thousands of pieces of content. That user was not terminated. That user then infringed the plaintiff Ventura's content. The defendant, before it actually published any content, looked at sort of increment snapshots of the content just to sort of make sure it wasn't child pornography or illegal obscene type stuff, and then would issue the posting. Some of the plaintiff's content had watermarks of some kind, but not all, and there was no formal written termination policy for repeat infringers. And so the district court dismissed the case at summary judgment, saying that it was a site really just functioning like YouTube with thousands of users uploading content. In short, there's no duty to patrol. At most, it could have general knowledge, and it didn't know if the content being uploaded was professionally produced rights holder content, or just, Joe and Jane Q public, uploading videos of themselves engaged in sexual acts. And so it issued a summary judgment in favor of the defendant. On appeal in the Ninth Circuit, the court affirmed, but with a vigorous dissent from one judge. The Ninth Circuit's affirmance, among many of the immunity issues, effectively held that there was no obligation to terminate that user account that had infringed given the facts and circumstances. And so it really gives a great level of deference to and support for online service providers. So if you're representing online service providers, that majority opinion is a very significant opinion in terms of just how little in essence can be done to deal with online repeat infringers and still not run afoul of the lines. A safer course would be to follow policies of YouTube, which are a little more stringent, obviously, but it's a very significant opinion for online service companies. Now, there was a vocal dissent. The dissent, and it's a published opinion, said what's effectively happened here is complete immunity. Quote, what defendant is really saying is that he looks at each thumbnail for a fraction of a second to identify repeat infringers. He uses his quote-unquote judgment rather than a policy to make the determination. End quote. And so, in essence, what the dissent said is that the majority has blessed a staggeringly broad concept of immunity. But that's the state of the law in the Ninth Circuit now. One last footnote. The Copyright Office has issued a white paper that noted this decision is wrong in its estimation, and that the dissent was right. The Federal Copyright Office asked Congress to do something, but Congress has not, however, done anything. So this is the law still. The Supreme Court has never touched the copyright immunity laws, but it did recently in 2023 speak to some issues that undergird the Section 230 immunity laws. This case is called Twitter versus Tamnay from May 2023. Basically, relatives of ISIS terrorist victims sued Twitter. They argued Twitter allowed content that radicalized others and led to the killings. Here is the core of it. ISIS committed terrorist acts in France, killed lots of people, and then claimed responsibility on Twitter. Family members of victims sued and said Twitter aided and abetted the crimes by failing to take action to delimit the activities on Twitter by the terrorists. But the Supreme Court rejected the argument. Now, this was not squarely a Section 230 immunity case because it was about the level of knowledge for aider and abetter liability. But, and critical here, the court noted that Twitter was agnostic to the content. It was neutral. It was arm's length. For social media companies, that is the litmus test for immunity. So this is an important case because it casts a long shadow to Section 230. It reaffirms the really broad immunity theory for social media sites that simply create platforms for speech and then sit back and remain agnostic as the rest of the world says their thing. So social media sites get massive content from you, from us, from the people, and we saw they have incredibly broad licenses to it. They have a copyright non-exclusive license from you to let them use, adapt, modify, and monetize your uploads. So out of the gate, the content filling their servers, they are acquiring copyright interests in. And then they have still more, a grant by you to let them use your likeness in specific advertising. That's a limited grant of your state right of publicity rights. So out of the gate, they have a lot of freedom to use everything we upload. And as we saw, they have two huge immunity grants in the law created in 1996 and 1998 at the advent of the internet era to allow a robust internet. And clearly the grants of immunity worked. As we saw, the immunities are very, very broad. And through case law, it has immunized a whole range of business models that look heavily content-focused you would otherwise think. And so the bottom line here is this staggering congressional concern to allow the development to internet took root in creating these immunities, and it stands today very broadly. You saw a variety of cases in the online defamation type area and the online copyright area, the twins areas of social media, and you saw the breadth of the immunity and how hard it is for plaintiffs to get through that immunity. We also saw that there has been some pushback by some in Congress, but nothing has been passed. And we saw the Supreme Court reaffirm some of the philosophical underpinnings of Section 230 in the Twitter case in 2023. This just reaffirms the strength of the immunity in the courts. Thank you today for listening and watching this presentation. Please, if you have any questions, just reach out. I'm always happy to help and happy to chat. Thank you.